I'm starting. Ask him. Can I start? My lords, chiefs, distinguished ladies and gentlemen, may I welcome you to Central Hotel, where we will be discussing matters relating to inheritance, the law of succession, and custom. We are obviously seated in Benin City, the ancient city of culture and tradition. What a place to beam from. It is often said that we exhibit the most attractive custom and tradition. And it has its own benefits, but it also poses its own challenges when it comes to succession. My name is Osaro Egobame, and I'm going to be moderating this session in the next 2 hours. I've had the fortune of partaking in the funeral rites of my late father, Sir Alfred Egobame, Senior Advocate of Nigeria. I've had the rare privilege of coming in contact with succession, custom, and estate planning. My father did not write a will, neither did he establish a trust, but what he did was to exhibit his very small intentions in a piece of paper. It's a tease statement, I would say. We loosely call it the dying declaration, perhaps inappropriately, because a dying declaration is a very specific statement which is made contemporaneously with death. But usually when you express your intentions, on a piece of paper, not so much regarding inheritance, but matters concerning how you like to be interned, how you like to be buried. My father stated that he had 3 children, biological children, and that he would prefer that my mother mourn him in a Christian way. He also stated that he had no other children, and that anyone who claims to be his child, other than these 3 gentlemen that he mentioned, should not be permitted to partake in his funeral rites. That was a very clever thing to do, because under the Benin native law and custom, if you do not, as a child, partake in the burial, you're not entitled to inherit anything. But worse, for the first son, if he actually doesn't conduct the second burial, as he said, he will not be permitted to inherit where the patriarch lived and died, arguably where he was buried. So that property where he lived, where he died, and arguably where he was buried, is often referred to as the stool property, the Gyogbe. Now, there are difficulties with these, because the whole intention is that the first son assumes the position of his father and takes the assets as well as the responsibilities in connection with liabilities. So let me give an anecdote to that scenario. Usually, man who's worked quite hard would have built his property, would have built a property. He may have married more than one wife. He's polygamist, has many, many children, and is working hard to take care of all of them. When he passes on, the first son is expected to continue to cater for his mother, to cater for his younger ones, and as a result, he steps into the stool of his father, takes over the property and takes over the assets. But what we're beginning to notice recently, and the court seem to have supported this, is that where a first son is recalcitrant, where he refuses to assume responsibility in connection with liabilities, he nevertheless is taken to be entitled to this property. That is not how the custom started. One or two cases have established that you must take the asset and liability. The problem, however, is that having assumed that position and taken the asset, if the first son refuses to assume responsibility with regards to liabilities, in other words, if he fails to take care of his mother, stepmother, children, what we're beginning to see is that he nevertheless is entitled to the property. So what normally happens is that he sends everyone out of the house, this Igiogbe that he didn't build, and then he says that it's his house, and then he attempts to sell it. Or usually when there's a dispute, you have inscribed on the building, this house is not for sale. If you go around Benin, most of the houses have inscriptions, this house is not for sale. I will talk about that briefly at the latter part of the discourse. So, we have very eminent speakers here to address some of these issues that continues to cause great problems and disputes. The courts are littered with matters relating to Igiogbe. Mr. Danine, who used to be the secretary to Obai Radio, will help us with this question of Igiogbe. There are other very complicated issues. The wife of the Benin man, especially, and not just Benin, across the country, is usually compelled to partake in the burial. But there are no provisions as regards our welfare. So it is assumed that the first son will take care of his mother and stepmother and the younger children. It is an erroneous assumption because many first sons will not take care of their stepmothers. What happens? This creates a social-cultural problem because the women are left exposed. So the women are suffering. We have Mrs. Aige, who is the president of the wives of the dukes in Benin. She's also a lawyer, so she will be giving us her perspective on how women are coping with what appears to be a harsh culture. Not harsh because, I use the word harsh, and I need to be careful when I say that, because if the custom were to flow or were to run in the way that it was originally established, the first son and the children will take care of the wife and the stepwives and the stepmothers, beg your pardon. But she will be dealing with that issue. But we have another set of problems. It's a problem, but it's a good one. We now have women who have assumed the position of stature. Some women are even wealthier than their husbands. What is the custom that applies to the distribution of the assets of a woman who has accumulated wealth? Is the spouse entitled to share in that property? What is the custom as it relates to distribution amongst the children? We know that some of the heads of the burial ceremony will distribute this applying the principle of primogeniture, in other words, the first son. Others have shared it equally. What happens where they're just female children? In the past, women themselves were property. So the custom had not developed to determine or to ascertain how property acquired by women should be distributed. I'm going to let Professor Yinka Omorogbe deal with that issue. At the last, she will speak because she can be quite volatile and she has very strong views. Some of it I disagree with, so she'll be speaking last. But then there's there are other problems that are that applies across board, which is, what is the tax treatment? What is the estate duty that you are expected to pay when property is being inherited? A lot of people don't think about this. But I can tell you, a lot of the property you see littered around the state is simply because people cannot afford estate duty. We have Anderson Tax helping us on the tax treatment, educating us on the tax treatment that is most appropriate for a particular estate plan. In other words, he'll be telling us about the need to choose a particular plan such that your tax liabilities are considerably reduced, and sometimes extinguished, in some cases extinguished. Finally, we as a law firm, Patch, Stone and Grace, in association with Egobame and Egobame, we are advocating that trusts can be used to circumvent a number of the difficulties that I identified. And there are quite a few more, quite a few that I haven't talked about, that we can use trust. And what is trust? It's a simple procedure by which you transfer the property from the deceased before he passes on to a third party for that property to be distributed in accordance with his intention. It is not a will, because the will is also subject to custom. So my father taught me something, and it's a simple way to understand trust. My father said to me, look, if I was unsuccessful, if I was living in a rented apartment, I would not have a problem with anyone coming and saying that it was my first son, or anyone competing regarding inheritance of a rented room, because I don't own it. So where the deceased is pauperized, where he has nothing, there is usually nothing to quarrel about. So what we do with structuring is to try and remove all his property from him during his lifetime and do it properly, not by way of gift, but by way of a trust deed. So we circumvent this difficulty of culture limiting your rights, especially where, in this case, the first son is recalcitrant or is undeserving of the Igiogwe. Sean, a good friend from Europe, will be talking about trust as it relates to property across Nigeria, particularly in this case Benin, that there is a way in which you can accumulate assets under a particular structure and have trustees settled in Europe actually helping you to deal with the property. So if you run a business, for example, the business usually will die with the testator. But if that business was run in other parts of the world, there are mechanisms by which the business transits from one generation to another. Sean will be helping us with that without going into great detail. Well, I think the discourse has to start, and I'm only a moderator. I just wanted to break the ice. I'm going to start with Mr. Dan Ine. Sitting as secretary to the Oba of Benin, Oba Erediawa, he had a lot of cases. He sat in council where a lot of cases were presented before the Oba, dealing with this question of who is entitled to the Igiogwe. Many of those issues related to situations where the first son was refusing to assume responsibility. I'd like him to address us on that question this morning. Thank you very much, sir. Nanine, please go ahead, sir.
Thank you, Mr. Moderator and discussant. Good morning. Good morning, everybody. I've met many lawyers defining Igiogbe as a place where a man lived and died. That is simplistic. It's simplistic in the sense that from what we know through the Benin window, there are two bylines. What defines Igiogbe for a hereditary title chief is different as a matter of details from what defines Igiogbe for an ordinary man who did not have any title while alive. So let's look at the two shades. for a chief, yes, where he lived, where he died, but where also the ancestral shrine altar was planted. That is important. For the ordinary man, yes, where he lived and died could be accommodated. Now, many of the cases we have seen coming for the Oba's attention, and we are aware of in Benin. Many first sons, they don't work hard enough. And when their father is deceased, they are interested in inheritance. Sometimes, because they did not work hard enough in life, the younger ones who have worked hard have more money. So they even help him for the burial. Now, as soon as that is done, he wants the house where the father lived and died. He wants another one. Sometimes he says he's the owner of everything. This has caused friction in many families. Now, the inheritor of Igiogbe is supposed to, by Benin expectation, well, almost like pre-colonial now, is supposed to take care of the younger brothers and sisters. The sisters who have the right to stay are expected to stay in the Igiogbe till they get married. The brother is not expected to send them out anywhere to the streets. For the men, he has a duty to assist the younger brothers to build their own houses and not kick them out, and support them to marry, because having assumed the position of the deceased father, he plays the role, is the father figure for all of them. He will give them wives and pay for the ceremonies. Now, for the wives of the deceased father, he takes care really of his mom. The other wife, there is a stage during burial proceedings that they are released to go back to their families. But one expects that since they were his father's wives, where he can help, he should continue to do so, particularly when those wives now lose their father or their mothers, we still consider their parents as in-laws into the family to which they were married. So it will be the duty of the first son, the inheritor, and the occupier of the building where they once married to go and support the burial of their parents, even though their husband, his father, has died. But many of the first sons we see today, some of them are not even aware of these responsibilities. Once they take over the house and they are collecting rent, that's all they want. So it has been a matter of very responsible succession for so many of them. Igiogbe, for the ordinary person, you see, many arguments have come up, but the traditional position is the house he lived in and he died. If he has houses all over the country, it's the particular one that he lived in, where he died, and where possible buried, that the first son has the right to take. But with time, we have also found that the first house built by a man is usually old Benin, made of mud, And as time goes on, he's able to build 4 flats made of bricks or cement, and so on. He progresses. He dies, and you find that the first son will be eyeing the 4 flats and not the mud house. This argument kept on coming up in the palace, and by radio I had to put in writing that the first son in such circumstances, rather than take a dilapidated mud building, he should be given the option to take any of the houses as a matter of first choice for him. In that case, his command over the first house of the father, now the Gilbert, will be taken up. Someone else will have to inherit that, trying to moderate. We have also seen situations where a man will have a house in Benin, but he has lived probably in Lagos all life. He lived there, he died there, and he will leave a will, bury him in a cemetery at Ikoyi. The question is, which one now will be his Gilbert? Is it the house in Lagos or the house in Benin? More often than not, the family will stand and say the Gilbert is the one in Benin because they originate from here, and whoever is taking the position of the late father should be able to supervise the family from the house in Benin. That argument has been there. But then comes the choice. The house in Lagos is in Ikoyi, it's very big, he knows he will make more money, but the Oba has said, okay, fine, take one. The one in Benin will no longer belong to you. So that is, we can develop on this conversation as the moderator begin to assign us with more questions.
Thank you, sir, for that exposition. And I'm going to follow up with some questions before I go to the other panelists. Where, for example, the first son has assumed the position of his father in the Igugbe, and assuming we establish that the Igugbe is in Benin, which is easier, and he fails to take responsibilities that he ought to have taken as a result of inheriting the Igugbe, can you reverse that gift? Because what's happened is that those who are affected nonetheless. So he's assumed that responsibility as first son, he's taken the main house, he's let it out, and receivables, and he's not taking care of his brothers and younger sisters who've been sent out of the house, by the way. Is it?
Well, there are so many practices in our custom that have one way only. It is not possible to take the property from him. Rather, we continue to admonish him to see reason in behaving better. But to take it from him, you will never be supported by any aspect of our customary practice. It is his, he has taken over, it's his forever. It's just a bad man, but it belongs to him.
Now, but when the custom was established,
our own customary management to reverse anything than to